Good morning. My name's Nick Mermiges, and I'm just going to explain prenuptial or antenuptial agreements and how South Carolina treats those agreements and how to do them right. The first thing that I want to talk about is the background here. Unlike the grand majority of states, South Carolina doesn't have one statute that regulates the scope of prenuptial agreements. Most other states have a specific statute that you have to comply with, and that also sort of lay out some boundaries for what you're allowed to negotiate about in the prenuptial agreement. Um, I'm sure that everyone, or at least most folks, know what a prenup is because they seem to have a pretty prominent place in popular culture, and there are sometimes high profile fights about them. But the long and the short is that a prenuptial agreement is a marriage contract where the parties before they get married can lay out certain property rights and pre-resolve certain disputes. And ultimately, they serve to limit things that you'd be entitled to in a divorce, such as alimony. Okay, you can have the spouses waive the right to alimony to one another. They are also used to limit inheritance. So if there's a wealthy couple contemplating marriage, you can have the spouse waive her right to the elective share of the estate, which is a statutory right to collect a certain portion of the total estate, and instead she's got to abide by whatever the husband gives her. And of course, these things go both ways. It's not just rich men and women coming into the marriage without assets. They also can operate to, for example, stop a spouse from having claims against someone's retirement that continues to accrue. So you've been working somewhere for 15, 20 years, you've been socking away money automatically in an IRA. Normally, that extra money that came into the IRA, that came out of your paycheck, would be marital property. In South Carolina, you're free to contract away the right to recover for that. And what's interesting about South Carolina law, and also troubling, is that there are really no clear boundaries limiting what you can negotiate away. Really, the only thing that is hands off forbidden is child support, because if you have a child, you can't really negotiate that child's right to be supported by its parent away. So that's void as a matter of public policy. But unlike a lot of other states, there's really no other external boundary on what you can negotiate away apart from unconscionability, which is sort of a judicial equitable decision that's very fact sensitive. So when you're drafting a prenup, there is a lot of freedom to think about how the parties want to allocate property rights and what they want to limit in terms of what you'd normally be entitled to in a divorce. There's got to be some limit at a certain point. I mean, you can't put in a prenuptial agreement that if you try to divorce me, you'll pay me $1 million. That would be unconscionable. And might even be unconstitutional on separate grounds. But there's not any clear case law or statutory authority in South Carolina that says this is what you do, and this is what you can do, and this is what you can't do. Now, how to have an enforceable prenuptial agreement, because if you go to the trouble of putting together a prenuptial agreement and then after years of marriage, a marriage dissolves and someone is able to overturn it, that certainly could be a rude awakening to the person who thought their assets were protected. And there is no perfect prenuptial agreement because at the end of the day, South Carolina courts are courts of equity. The family court is a court of equity. Equity means fairness. And one of the factors they consider when deciding whether to enforce portions of or the entirety of a prenuptial agreement is whether the circumstances have changed. Okay, so if entering the marriage, the wife and the husband both worked and they were both very healthy, but then during the course of the marriage, the husband quit his job to take care of the kids, and then the husband also got sick, and now he has all these medical bills, and the wife's earnings have continued to grow, that change of circumstances can warrant a modification of or just complete disregard for portions of a prenuptial agreement. So there is no silver bullet, but I can tell you that the appellate opinions and the Supreme Court opinions in South Carolina are very strong, okay, in favor of enforcing prenups. Very, very strong. Stronger than probably just about any other state in the country, or as strong as any other state in the country. But before you can get to the point of enforcing it, you have to have an enforceable prenuptial agreement. And so I'm going to run through a few of the most important requirements of drafting a prenuptial agreement and executing it, meaning how the parties sign it, because these agreements are signed in contemplation of an impending marriage. Okay, and that's a very emotional time and an emotional situation, and folks get all excited and irrational, and so the family courts hold parties to that agreement to a higher standard in demonstrating that the other party knew what they were getting into. Okay, in a normal contract law does not provide this degree of latitude, looking at the subjective knowledge, to use lawyer words, of the party executing the agreement. And what do I mean? So what I mean is courts in South Carolina will actually consider whether the person had time to read and think about the agreement, whether they had their own attorney to advise them. They'll actually look at the amount of time between when the agreement was signed and when the wedding happened. So if the agreement is executed on the day of the wedding, that's a problem. That suggests duress, or at the very least, it suggests that the person that's getting into the agreement didn't know what they were getting into, and they're not going to be bound by it, or they're unlikely to be bound by it. Okay, whereas if it was executed 2 weeks before in an attorney's office, and the attorney was retained specifically by the wife, for example, then that's far more likely to be enforced, because then the wife had independent counsel of an attorney she retained herself, and she had plenty of time to think about it, and she wasn't forced into signing it, or there wasn't this exigency of, if you don't sign this, we won't get married, and it's going to be a huge social disaster. Everyone's come to this wedding. It's that kind of thing. So there's got to be as much lead time as possible. Okay, that's one requirement. The other requirement is that, and this won't be fatal, but if you're going to be a responsible person who's actually taking the time to do this and protect your assets, both parties have to have independent attorneys that advise them. It can't be an attorney that has a relationship. It can't be like the husband's golf buddy advises the wife. It's got to be an independent attorney. They need to be paid for their time. They need to look through the agreement and give full advice about the contents of the agreement. And they should actually execute an affidavit that they done so, and that should be incorporated into the agreement from both sides. Okay, so time, independent counsel. What else? Obviously, it's got to all be in writing. It's got to be clear and specific. Okay, it's got to be in writing, and it's got to be executed properly by both the parties to the marriage. And so that means signed and notarized by both the husband and the wife. Okay, and when I say notarized, I mean you go down to a notary public, and that way it verifies that this is really their signature, because someone looked at their driver's license and verified that. So written, executed, independent counsel, ample time to consider the agreement. Okay, those are 4 things. And the 5th one, which is actually the most important, is full financial disclosure. Okay, I said earlier there's no statute that governs prenups in a comprehensive way, and that's absolutely right. There isn't one. But there are specific rules. Okay, there's a rule of family court that says that in order to be presumed valid, a prenuptial agreement has to be in writing, executed by both spouses who had independent counsel, and it has to contain the full financial disclosures as provided for in these rules. Okay, and I know these are just legal words, but what does that mean? That means that the disclosures that you would make when you were getting a divorce about your assets and your debts and your income, the comprehensive financial disclosures, you should be making those identical, complete disclosures in your prenup. Okay, those should be attached to your prenuptial agreement, because if one side or the other doesn't know what assets the other side has, then they don't know what rights they're giving up. They don't know how much alimony they're giving up. They don't know what potential rights to equitable division they're giving up. Okay, and so again, that's the somewhat heightened knowledge requirement. And if it comes out that certain assets weren't disclosed, that can be seen as fraud in the inducement or a material misrepresentation. Okay, and that would invalidate the entire agreement. I would also note that there's actually other statutes as well that require that the specific assets be in writing. I'm not going to cite the code for you. I actually wrote an article on this that cites the code, but there's a separate statute about the wife's property interest in marriage, and it specifically says that marriage contracts have to spell out the property that's covered. Okay, and that's a specific requirement. And then the probate related code. So probate would be when someone passes away and you admit a will to probate. When it comes to wives or husbands forfeiting or agreeing to forfeit their elective share or their share of the inheritance, that's got to be in writing, and the assets have to be specific statutory support showing that you have to have full asset disclosure. And also all the South Carolina courts that examine these things say you got to have full and fair disclosure, and that's what they're talking about. So in review, it's got to be in writing, executed by both parties, all represented with their own independent counsel. They got to have ample time to make the decision, and there has to be full asset disclosure. That is the basic substance of ensuring that a prenuptial agreement is going to be enforceable. That doesn't mean there aren't defenses. Okay, you can argue that it was unconscionable, which basically means this was totally unfair from the start and you should invalidate it. And that's a somewhat tough argument to make, but it has been recognized. Okay, and then there's also change of circumstances. And that was what I described before, which is a lot of things happen during marriages, and it's not always fair to hold one party to an agreement when things have changed so much. So that's an initial overview of prenuptial agreements. Obviously, you should have a lawyer who knows about prenuptial agreements assist you in drafting one, or if you're unfortunately planning on getting a divorce, you should really have an attorney look at the prenuptial agreement and ask you questions about the circumstances, about how it was executed, in order to determine whether or not it's likely to hold up in a court of law. So if you have any other questions, or if you need help with a prenuptial agreement, you can always email me, Nick at nicklawsc.com, or you can pull my office contact info from my website, which is nicklawsc.com. I'm on Main Street in downtown Columbia, and I would certainly love to answer any further questions you might have. Thank you for your time.